I want to start with talking about the discovery process. As the court knows, we have been representing Mr. Kohberger since the very end of December of 2022. And during the course of the last several months, there has been a lot of discovery that's been requested and a lot that's been supplied. I come here asking the court to compel discovery. I'm seeking an order directing that we receive this discovery. I'm not seeking any other kind of sanction. I don't come here saying that the prosecutor has done something wrong. I come here saying that there are things that we have a disagreement about whether I should get them or when I should get them, and we seek a court order to assist us in this regard. Yesterday, we filed an exhibit that related to our motions to compel, and the purpose of that exhibit was to show the court how the discovery is coming in and what we are weeding through to try to find the information, and to let the court know that our office is making extraordinary efforts. Mr. Kohberger's team works nonstop, and when we ask for discovery, it's because we have reason to believe it exists. So I wanted the court of counsel to be aware it's not a fishing expedition. These are real items that are really necessary to investigate this case and prepare Mr. Kohberger's defense. So with that as the background and the frequent communication with the prosecutor's office to try to obtain the materials we need, we have come to an impasse in a few areas, and that's what brings us to court today. As the court knows, discovery is governed by statute 1309 and Idaho Criminal Rule 16. And the purpose of discovery is really to prevent an unfair trial, to prevent trial by surprise, and also to protect a charged person's rights to meet their defense. It protects their Sixth Amendment rights to have a sufficient and a prepared counsel, I should say, as we have a duty to investigate the case. So in preparing our case for Mr. Kohberger, we've asked for several things that we still need. I'll talk first about request number 6 in the first motion to compel, and that stems from discovery request 160. It's training records. These are training records of 3 specific police officers. Your Honor, we have not asked for training records for every officer that has had anything to do with the case. I would not want to stand here and let the court think that this is an exhaustive list of the officers that we might need training records for. But these are 3 officers that we've requested them for, and the state has indicated they're not willing to give us the training records. These 3 officers are officers that have each conducted critical interviews with critical witnesses in the case, made decisions about the interviews, made decisions about evidence, and conducted other kinds of investigations. We seek their training records to understand their processes. The training records, Your Honor, they are records that we've been able to obtain from various police agencies in the past. In this circumstance, they're not records that I can find on my own. These are not things that are on the internet. They're not going to just hand them over to me. The 2 of the officers that we've requested them about are Idaho State police officers. I have often received training records for Idaho State police officers in the preparation of other cases during the course of my career. They are imperative for us to understand the specialty in interrogating and interviewing people, and for making the decisions that they made with regard to things taken as evidence in the case, or things followed up on or not followed up on. So that is the purpose for those records, and we're asking the court to order the state to provide the training records for those 3 officers. Moving on then to our second motion to compel, and what we are looking for is a lot of information from the FBI CAST team, as well as the FBI Forensic Examiner team. What we're talking about here is the CAST team are the FBI examiners that use cell phone records to provide a lot of information that found its way into the probable cause affidavit that the state relied on in arresting Mr. Kohberger. I had the opportunity to meet with the prosecutor, and they indicate that we will be getting those items in number 1 and number 6 disclosed to us, but we don't know when. So I'm asking this court to issue an order with a date certain to obtain those records. These are bits of investigation that the FBI conducted that relate to Mr. Kohberger's cell phone, and the state has relied on that in their affidavit to say that Mr. Kohberger was in certain places at certain times. So these are bits of information and analysis that's been done since December. We are now at the end of June. We do not have those records yet, Your Honor. They are something that's been relied upon by the state for the PC affidavit to arrest Mr. Kohberger, as well as to obtain a variety of search warrants. It's information that the state has agreed we should have, so we ask the court for an order with a deadline to get that. I want the court to know I don't think that Mr. Thompson or Ms. Jennings are trying to withhold this. I think they'll give it to me when they have it, but I think an order from the court saying this is the date certain may help them get the information a little bit more rapidly. I'll move on to our last request, and that's number 2 in the second motion to compel, request number 4. And that has to do with the FBI forensic examiner that told the state to look for a white Hyundai Elantra. This is the examiner that originally there were certain years looked for, and that year range was expanded. I believe I have the communications between the police department and the FBI about how that date range changed, but what I don't have is the report from the examiner. I did receive the CD, curriculum vitae, from about the examiner late yesterday from the prosecutor's office, so I'm asking the court to order a deadline for the report to be given to the defense. Again, the court's read the probable cause affidavit that led to Mr. Kohberger's arrest, and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Kohberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with a deadline so that we can get that. As the court is aware, the state has a duty to provide discovery to the defense. As the court is aware that not producing discovery, especially when it's material, can be a due process violation. And as the court is aware, the state has filed its notice of intent to seek death against Mr. Kohberger. These are critical, relevant materials, all of them, including the police training records. They're necessary for us to prepare and present our defense of Mr. Kohberger. They're necessary for us to do our investigation. They're necessary for us to prepare our case and our motion practice moving forward. These are things that we need to have. There is a heightened standard now that the state has filed its notice of intent to seek death, and these are very relevant, critical bits of information. They are discoverable, and we're asking the court to order that they be supplied to us.